Welcome to the Deep Dive. We're here to take complex rules and really break them down into something practical you can use. Today, we're getting into a tricky area of tort law. What happens when the danger isn't outside the car, but sitting right next to the driver?
Yeah, we're talking about passenger actions. Like, when does some totally unexpected thing a passenger does, maybe grabbing the wheel, become the driver's legal problem? When does that shock turn into responsibility?
That's exactly the puzzle. So our goal today is to unpack this using the classic negligence framework: duty, breach, and proximate cause. And really, for these passenger cases, it all comes down to one core idea we need to model. How does that first incident, that initial shock, change things? How does it make future bad acts foreseeable, shifting the driver's duty?
Okay, let's start there. The duty itself. What's the basic duty a driver owes a passenger? And what if the driver's just a kid, a minor? Does the law give them a break? Right. So the general rule on duty is, well, it's quite clear. A driver owes passengers a duty of reasonable care. It's always foreseeable that careless driving could injure them. Simple as that. Now, about minors. No breaks. The law is firm. A minor driving a car is held to the exact same standard of care as an adult in the same situation. Driving is serious business, no matter your age. And there's a related idea. The passenger usually gets to assume the driver's being careful. They don't have to backseat drive unless, they know the driver's drunk or clearly incompetent or something like that.
That makes sense for typical driving mistakes. But the tough part is managing other people. So when does this basic duty stretch to cover preventing what other passengers might do?
Ah, yes, the foreseeability hurdle, as you called it. If a passenger does something truly out of the blue, totally unexpected, that causes a crash. Generally, the driver isn't negligent. You can't predict genuine random chaos. But, and this is the crucial part, when those passenger actions do become foreseeable, maybe because they've done something dangerous already, then failing to try and stop it can be a breach of the driver's duty to the other passengers. Awareness changes everything.
Okay, let's make this concrete. Let's talk about that Delaware case, Pipher v. Parsell. I mean, before we even get into the formal step, there's that one moment, right? After the first wheel grab, the driver gets control back, and then he and the passenger who did it just laughed. Like it was a joke. Is that the instant the legal responsibility really clicked in, that failure to take it seriously?
You nailed it, that awareness followed by treating a serious danger lightly. That's basically the whole case in a nutshell.
All right, let's analyze Pipher v. Parsell properly then. First, what are the legally dispositive facts?
Okay, the key facts. Parsell, the driver, was 16. Pipher, the plaintiff, and Parsell, the other passenger, also 16. They're all in the front seat of a pickup going about 55 miles per hour. Then Parsell suddenly grabs the steering wheel first time. The truck swerves off the road shoulder. Parsell manages to get it back under control. Critically, Parsell later testified he was shocked, sure, but he knew how dangerous it was. Yet he did nothing. No warning, nothing. Instead, he and Parsell laughed about it. Then, maybe 30 seconds later, Parsell does it again, grabs the wheel. This time, the truck crashes and Pipher is injured.
And what was the core legal issue the court had to decide?
The precise legal question was, did Parsell breach his duty of care to Pipher? Specifically, by not taking reasonable steps to stop Parsell from grabbing the wheel a second time, especially after that first grab put him on notice.
Got it. So what rule of law did the court use to figure this out? Can you state the rule and its elements?
Sure. The underlying rule is just standard negligence. To prove negligence, the plaintiff, Pipher here, has to show 4 things. 1, a duty of care was owed. 2, the defendant breached that duty. 3, that breach was the proximate cause of the harm. And 4, there was an actual injury. In this case, the real fight was over element 2, breach. And resolving that breach question turned entirely on foreseeability. Was the second grab foreseeable after the first one?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, duty of care?
Well, the basic duty wasn't really in dispute. Parsell was driving Pipher, so of course he owed her a duty of care. That's standard. What the court focused on was how the scope of that duty changed after the first grab. Once Parsell knew, once he was on notice that Parsell might interfere with the steering, his existing duty expanded. It now required him to take reasonable steps to protect Pipher from that specific, now foreseeable danger. His awareness ratcheted up his responsibility.
Okay, the duty got broader because the risk became specific and known. He knew what could happen next. Now onto the real heart of it, the second element, breach. How did the court look at the 30-second gap between the 2 grabs to decide if Parsell failed in his duty?
Right. This is where the appeals court really disagreed with the trial judge. The sub-issue here is foreseeability again. Was that second grab foreseeable? The trial judge thought, no, lightning doesn't strike twice, basically. He assumed it wouldn't happen again. But the Delaware Supreme Court said, hold on. They looked at similar cases, like one from Vermont, and said the rule is when a passenger does something really dangerous, the driver has to make a reasonable attempt to stop it from happening again, applying that here. Parsell's own words were key. He admitted he knew the first grab was serious. That put him on notice. He even admitted later there were things he could have done: yell at Beisel, pull over and make her sit somewhere else, threaten to kick her out. Because he did none of those things, absolutely nothing. After being alerted to this specific danger, the court said a reasonable jury could find he breached his duty. He let a known risk continue unchecked.
Hang on, though. Let's be real. He's 16. He just avoided a major crash at 55 miles per hour. Shock, relief. Are they really saying that in the next 30 seconds he needed to pull over, conduct a disciplinary hearing? That feels incredibly demanding.
It does feel demanding, and I'm sure that was argued forcefully. But the legal standard isn't perfection, it's reasonableness. What would a reasonable person do after being put on notice of such a serious danger? The court wasn't necessarily saying he had to pull over instantly, but doing nothing, not even a sharp word, especially when he admitted he had time. 30 seconds isn't instantaneous, and understood the risk, and then, crucially, laughing about it. That suggested he wasn't taking reasonable steps. The laughter really undercut any argument that he was too shocked to act reasonably. It showed a failure to appreciate the gravity, which points towards breach.
Okay, that framing makes the laughter feel much more significant legally. It's not just bad judgment, it's evidence against taking reasonable care. All right, let's move to the crucial third element, proximate cause. So maybe he breached his duty by doing nothing. But how can we be sure that anything he did do would have actually stopped Beisel the second time? Didn't the lower court say her action was just her own fault, breaking the chain?
Yes, exactly. The trial court did rule that way initially. They said Parsell's inaction wasn't the proximate cause, that Beisel's second grab was like a separate, independent act cutting off his responsibility. But again, the Supreme Court reversed this. They said, look, whether Parsell's failure to act caused the injury isn't a question of law for a judge to decide here. It's a question of fact for the jury. The jury needed to decide. Was it reasonably likely that if Parsell had acted, if he'd yelled, pulled over, threatened her, would that have probably prevented the second grab? Since reasonable people could disagree on that outcome, it had to go to the jury. The judge couldn't just say, nope, no causation possible.
Okay, so duty was established and expanded by notice. Breach was a jury question because he failed to act reasonably after notice. Proximate cause was also a jury question. So after analyzing all the elements, what was the court's final conclusion?
The final holding was that the trial court's decision, the judgment as a matter of law, or JMOL, was wrong and had to be reversed. A JMOL basically means the judge thinks the case is so one-sided that no reasonable jury could find for the other side. The Supreme Court said, no, that's not right here. Reasonable jurors could find that Parsell breached his duty after the first grab made the second grab foreseeable, and they could find that his failure to act was a proximate cause of Pipher's injuries. So the case needed to go back for a jury to decide those factual questions.
This makes me wonder about the bigger picture. What's the underlying policy? Why is the law potentially so strict on the driver when they become aware of a dangerous passenger? Why force them to intervene like that?
It really comes down to control and the duty that flows from it. Think about that Vermont case again, the playful fellow grabbing the driver's arm. The driver is in a unique position. They're the one operating the vehicle. They're the one who can stop the car, who can tell someone to get out, who can change the seating. Passengers, like Pipher, are essentially relying on the driver for safety, not just from external road hazards, but also from foreseeable dangers inside the car. So the policy is, if you, the driver, become aware of the serious risk posed by one passenger to others, and you have the means to reasonably try and mitigate that risk, the law expects you to do so, because often you're the only one who can. As the court put it, that knowledge should forecast the peril to a reasonably prudent driver.
So it's less about punishing the driver's lapse in judgment and more about protecting the vulnerable passengers who depend on the driver exercising the control they uniquely possess.
Precisely. The duty is primarily owed to those, like Pipher, who are put at risk by the situation and can't control it themselves. The driver is seen as the last line of defense against that known internal threat. So let's try and synthesize this into a tool for you, the listener. When you're looking at an exam problem, maybe involving passenger misconduct, here's a kind of diagnostic checklist you can run through. Step 1, general duty check. Is there a basic duty of care from the driver to the injured passenger? Almost always yes. And remember, it's the adult standard of care, even for a minor driver. Step 2, Foreseeability check, no notice. Was the passenger's act a complete surprise? A one-off, totally unpredictable event? If yes, probably no breach by the driver, unless, maybe, the driver knew beforehand the passenger was likely to be trouble, like visibly drunk or agitated. Step 3. Foreseeability check with notice. This is the Pipher situation. Did the passenger do something first that put the driver on notice of a specific danger? Like Beisel's first grab, that's the key turning point. Step 4. Breach test. Okay, after the driver was put on notice, did they fail to take reasonable preventative action? This doesn't mean they had to guarantee safety, but did they do something reasonable? Warn the passenger, try to separate them, pull over, threaten removal? If they did nothing when they reasonably could have, then a jury can find they breached their duty.
That checklist really clarifies the flow of the analysis based on Pipher. And thinking back, that moment they laughed it off, it really was the pivot point, wasn't it? It signaled a failure to treat a known serious risk with the seriousness the law required. It underscores that legally, a driver has to react to danger as danger, regardless of whether the people involved are treating it like a game, something important to mull over. Well, that was definitely a deep dive into how a driver's awareness can significantly expand their legal duties. Hopefully, walking through Pipher element by element gives you a solid framework for tackling foreseeability and breach in negligence cases.